A huge victory today as the Ninth Circuit Court of Appeals finds California's ammunition regulations set forth by Prop 63 all the way back in 2016 unconstitutional, affirming what the federal district court in San Diego said twice as we continue to see the progression of Rhode v. Bonta. Let's talk about it. Hey everybody, welcome back to the channel today. That's right, you saw it in the thumbnail, you saw it in the preview. It is a victorious day for the Second Amendment in California as we see a Ninth Circuit opinion rule in favor of California gun owners in the Rhode v. Bonta lawsuit. To walk us through that today, we have a couple of guests to come on. First, we've got Brady, who is an attorney with Michel and Associates. He's been on this case since day one, argued in court at multiple levels, the federal district court as well as the Ninth Circuit Court. Sean, thank you very much for coming on today.
Thank you for having me.
Of course, and also, we have Kim Rhode, who, if you don't know this by now, she is the named plaintiff in the Rhode v. Bonta lawsuit. She's a huge advocate for the Second Amendment in California, a huge advocate against these ammunition regulations, and a huge advocate for the shooting sports in California. Oh, by the way, she also happens to be one of the most decorated Olympians in U.S. history, competing successfully in the shooting sports at the national and international stage for decades now. Kim, thank you very much for coming on with us as well.
Thanks for having me.
Much appreciated. And guys, before we get into this today, as always, be sure to like, share, and subscribe to these videos. Throw some comments down in the comment section below. It's a great day. CRPA for the win. Hashtag gun rights for Californians. This is going to be a good day and some good progression moving forward. And guys, if you haven't done it already, also in the description below, become a member. It's a great time to be a part of this movement, whether you're in the state or not in the state. The link is down below to become a member. That's a great way for you to contribute to the litigation and legislative efforts here in California and victories just like this. So, Sean, we normally read from the opinions when these things come out, but let's give a little bit of context first, perhaps for those of us who may have been on vacation for the last 9 years in Poland or something like that. As far as this lawsuit is concerned, what is the complaint that we had originally dating all the way back to 2016? What was that complaint addressing, and what's been the pathing of this lawsuit through the court system?
Well, we'd be here all day if I had to explain everything that happened, but essentially Proposition 63 was put on the ballot, supported by Governor Newsom and others who were trying to say that the legislature wasn't doing enough on gun control, if you could believe it, that. And so they got smart and put it to the people because they're able to lie to the people about what are the contents of the laws. They don't have to deal with legislators who understand somewhat the little things that can happen and need to be fixed and made and done differently. So rather than go to the legislator and do that difficult process of convincing folks that this is a good law and dealing with lobbyists who know what they're talking about, they just decided to go straight to the people. And obviously that caused a little bit of conflict with the legislators and Governor Newsom, but they ultimately all got on board. And Proposition 63 was this just enormous slate of all sorts of gun control, including the restriction on large capacity magazines and other things that were challenged in other lawsuits. But this lawsuit dealt with the portion of Proposition 63 that had regulated ammunition transactions, right? And essentially what it did was requires people to go to a licensed ammunition vendor. You can no longer just buy ammo at the gas station. It has to be an entity that gets a license to be able to sell ammo, and it has to be in person, face to face. So that means no more purchasing over the internet, from a company like Ammunition Depot or Able Ammo, which are plaintiffs in the lawsuit. And you couldn't go out of state to say, go dove hunting in Arizona and bring back your leftover ammo. You would have to leave it there, or you would have to have it sent to an in-state vendor and then go and pick it up and go through a whole background check. So just on paper, the whole law looked pretty bad, obviously. And so we challenged it under various grounds, the Second Amendment, with respect to all the restrictions, but also on dormant commerce clause grounds, saying that the state of California cannot restrict the shipping of ammunition from out-of-state companies to Californians because it essentially cuts them off from the market. It gave California retailers essentially a monopoly on ammunition purchases in California. So we brought it on those grounds, and also as restricting or as being preempted by federal law, the Federal Firearm Owner Protection Act, which essentially allows residents of different states to cross state lines with legal firearms and ammunition without being jammed up by local laws that they might otherwise be violating, as long as the destination they're going to allows the items that they have. So we brought these challenges and not knowing that the state of California would make the case even worse than it was on paper, right? On paper, it looked bad, but in its implementation, what ended up happening was the system just didn't work. There was delays. There was people being denied, not denied. So denied means when you go in to get a background check, if you're denied, that means that the state of California Department of Justice has determined that you are not entitled to firearm. You're a prohibited person, so you can't buy firearms or ammo. But here they create this whole new category of rejected people, right? So if you weren't able to satisfy the Department of Justice in their background check, then but they didn't determine that you were prohibited, they just could not confirm that you were not, they would put you on the rejected list, right? And it could be something as trivial as you changed your address. And so the address that the DOJ had in their system, their automated firearm system for maybe your previous firearm purchase, now that your new ID has your new home address, they would reject you just for that. And then they wouldn't even explain to you exactly why you were being rejected. You would have to go and sort of investigate your own case and then figure out that you have to go on their website and update records and figure everything out and then try again. And obviously that caused a huge problem. I mean, we were talking about, I think it started out being about 18% of people who were trying to buy ammo were put in that position. And now I think it's still, all these years later, 8 years later, it's still about 12% of people, which is, that's 12% of people trying to exercise their right being rejected for trivial things is unacceptable. And tellingly, almost half of those people who were rejected never went on to go back and buy ammunition legally. So this was causing, these are thousands, the numbers are thousands, tens of thousands of people. So while on paper this law was bad, in practice it was even worse. So seeing that, we brought a preliminary injunction out of the gate to get this law stopped, saying, look, court, this is an emergency because we're talking about 15% of people who are entitled to exercise their rights being unable to do so for trivial things. And unfortunately, the court entertained that motion, but wanted more information and gave the state a year or so of rope to go on and show that it was fixing things, right? That it wasn't just an initial glitch in the system, to prove that it wasn't baked into the system. And so over the next year or so, the court was ordering the Department of Justice to provide it with declarations explaining who was rejected, why they were rejected, the rates of rejection. And that ultimately prove that it was not just a glitch in the initial system. It was a feature of the system. And so the trial court granted a preliminary injunction. And unfortunately, that injunction was stayed when we went up to the Ninth Circuit, meaning we got a win on paper, but it didn't have any effect. The law was still being enforced. And so in the Ninth Circuit, we drew what was on paper probably an unfavorable panel. If you had to guess, if they were going to ultimately rule, we were not too excited about our prospects of prevailing in the ninth. But interestingly, that panel, even one that appeared pretty hostile, struggled with ruling in the state's favor because it post oral argument it requested 2 additional rounds of supplemental briefing on distinct questions that I think it was trying to get to the bottom of, like, is this right, state? Like, we want to rule in your favor, but these things are pretty bad. We need some help in like justifying this. Is sort of my read, obviously. But ultimately, because the Ninth Circuit took so long in doing all this additional briefing, during that time, the United States Supreme Court took up the infamous Bruen case, which I think everybody listening knows about that case. And so the Ninth Circuit did what pretty much every other court did in the country at that time, and they stayed all Second Amendment cases pending a decision from SCOTUS on the Bruen case. And once the Bruen opinion did come down a year or so later, the Ninth Circuit decided not to rule on our case, on the Rhode case, and decided to send it, remand it back down to the trial court. And so we were basically starting from scratch under Bruen, and we went back down, and it ended up being a good thing, I think. Like I said, I didn't really have a good feeling about that panel's ultimate disposition of the case anyway. So we avoided that, but obviously it took a lot of time. We went back down to the trial court, had essentially a mini trial before Judge Benitez in San Diego on the merits, got a final judgment in our favor, prevailed. Again, the state requested a stay of that ruling, of that injunction on all the laws, and that was granted. So we went back up to the ninth with a stay in place again. And this time we drew what obviously, after today's ruling, was a favorable panel. And now we are sitting good with a victory.
Yeah, and I think there's a couple things that are definitely worth noting there. So, I mean, you've got the original regulations that came down in 2016, which sort of kicked off the lawsuit, but the Rhode case was part of the remands in mass that came after Bruen. So I guess the first thing to note there is that, this is progression. Just seeing an opinion from the Ninth Circuit is progression in this case. And the second thing is that we got a final judgment. We've also done a lot of talking about the Supreme Court in general. It's been flagging the community that it really doesn't want to see cases come up on interlocutory appeals, which are appeals for preliminary injunction and things like that. It's continued to remand cases that are up there on those sorts of appeals, asking for judgments in those cases. So definitely a couple of good things to note, and that is the legal context here. Sean, thank you very much for that. Kim, if we could go to you really quick just to get a little bit more of the cultural context before we read from the opinion here. You had these regulations take effect, and nobody really likes their application, right? Anybody who's going to purchase ammunition doesn't like the fact that they can't get it by the means in which they've been getting it for their entire life. They don't like being subject to a background check, but something that you can't really get around is the fact that there are disproportionately some people within the community that just have a lot more ammunition purchases in general. The first thing I look to is the shooting sports. So if you can take yourself back 8 years, what was the initial effect of Prop 63's ammunition regulations culturally within the shooting sports and the firearms community?
Well, I think I'm definitely one of those people that obviously shooting as much ammo as I do, being an Olympian, we're going through 500 to 1,000 rounds a day. So, it is very important to competitive shooters, to athletes, but just to the general public as well. And so there was a lot of challenges. And one of the things that really struck me is when I'm competing, going over to another state, like say Arizona, shooting a selection match, having to purchase ammo there, and then having leftover because we have shoot offs. We don't know that exact number. And then it becomes, well, I can't bring one shell back, but what do I do with it? Do I just leave it at the state line? And these were all challenges that the shooters were facing, both on the competitive side as well as just the everyday shooter. And I think really for me, I mean, the reason I took this case on in the first place is because it was wrong. Prop 63 really made it harder for legal gun owners to simply just buy ammo. And I think that was something that was tragic because, I spent my whole life, following the law, representing the United States, with honor and, standing up for the values of this country that, what it was founded on. And I just couldn't sit back any longer and let our rights be chipped away. And that's really what this was just chipping away at our rights.
Yeah, absolutely. And a downward trend culturally for California, to say the least. So having that context, bringing it to where we are here today. Jacob, if you could pull it up, let's go ahead and read the summary from the opinion itself. It reads like this. Affirming the district court's grant of a permanent injunction, the panel held that California's ammunition background check regime, which requires firearm owners to complete background checks before each ammunition purchase, facially violates the Second Amendment. The panel applied the two-step framework set forth by the New York State Rifle and Pistol Association v. Bruen in assessing plaintiff's Second Amendment challenge. Applying the first step, the panel held that California's ammunition background check regime implicates the plain text of the Second Amendment because the regime meaningfully constrains the right to keep operable arms. Applying the second step, the panel held that the government failed to carry its burden of showing that California's ammunition background check regime is consistent with the nation's historical tradition of firearm regulation. The historical analogs proffered by California were not within the relevant time frame, nor were they relevantly similar to California's ammunition background check regime itself. Accordingly, the panel held that California's ammunition background check regime did not survive scrutiny under the two-step Bruen analysis. The panel next considered Bruen's footnote stating, nothing in the Supreme Court's analysis should be interpreted to suggest that unconstitutionality of the 43 states shall issue licensing regimes. The panel explained that the Supreme Court indicated that shall issue regimes may be constitutional, but did not hold that they were per se consistent with the Second Amendment. Moreover, Bruen shed no light on the constitutionality of the ammunition background check regime, which is meaningfully distinguishable from a shall issue licensing regime. Finally, the panel considered that implications of the nature of plaintiff's facial challenge to California's ammunition background check regime. The panel held that Bruen's two-step framework applies regardless of whether a plaintiff brings a facial or as-applied challenge to a law alleged to violate the Second Amendment. Because California's ammunition background check regime violates the Second Amendment, the panel held that the district court did not abuse its discretion in granting a permanent injunction. And guys, I promise I will try not to say the phrase ammunition background check regime one more time this video. We'll just call it Prop 63 or the law. So, Sean, you kind of have a lot of focus here within the opinion on the background checks itself. In your summary of the complaint, there were a lot more challenges that we had in this lawsuit than just the background checks. Is that because everything sort of stems from the background checks itself? Do we have victories on all of our challenges with this lawsuit, or does it specifically pertain to the background check system itself?
No, I think that the court, and again, I've just got the opinion, an hour or so ago, and I've been evaluating it, so I'm still digesting it. But I think that that's just sort of shorthand. Talking about the ammunition background check scheme that the court's using to discuss the entirety of the regime, which includes the other statutes, because the trial courts, the district courts injunction applied to all those statutes, right? The restriction on face-to-face, on importation. My understanding is that this applies to all of them, and the court went out of its way to expressly mention that it didn't need to evaluate our Dormant Commerce Clause challenge or our federal preemption challenge because it had already disposed of those questions under the Second Amendment. So it said that all these statutes violated the Second Amendment. It wouldn't say that if it hadn't disposed of those. It would have had to have addressed those other those other theories of unconstitutionality. So yes, all of the statutes that were at issue here have the injunction that the district court set out has been affirmed in full, which applies to all of those major restrictions. There are still some that survive. Like I believe that ammunition vendors will still need to get a license to sell ammo, but there won't be any of the other issues that come along with that, like the background check and the restriction on shipping ammo.
Well, definitely good to see there that the entire complaint ends up being sort of encompassed in what they call the background check regime. Kim, over to you again. Really quick. We kind of talked about the downward when Prop 63 came in. Now we're looking at the upward. But having said that, this isn't the only thing that's really attacked the culture in California. Gavin Newsom, when he came into office, basically stated he wanted to attack firearms culture in California and get rid of it. We've seen other things that have affected us culturally here. The biggest one that I can think of was Assembly Bill 2571 that really ended up affecting scholarship opportunities for the shooting sports for Californians. And we've had a couple of people testify up in Sacramento pertaining to that specifically, as well as in the courts. How do you see this recent opinion affecting the culture in California? Does this open up opportunities when it comes to being an advocate for shooting sports in California?
Oh, most definitely. I mean, I think I can say, like everyone else, I've seen firsthand how the policies like Prop 63, don't just restrict access, they've choked off opportunity. And it's not just about the athletes who managed to stay in the sport, but it's about the ones who never got to start. And I think families walked away because the laws are confusing. I mean, the youth programs were struggling. Kids with real talent never got the chance to really take that first shot. And it's not because they lack discipline or passion, but it's because the state made it too hard for them to even begin. And so Prop 63 is just one piece of it. But California keeps introducing, bill after bill, more taxes, more red tape, more ways basically to quietly shut down our sport. And it's basically what they call it, death by 1,000 cuts. This case really was something about standing up. I mean, for me, that's what it represented, standing up for the sport, for the next generation, and for the rights that, we are all guaranteed. And shooting, I think has given me such a wonderful life, a life that I could never have imagined. And I'm basically fighting to make sure that others still have that same chance that I did.
Yeah, absolutely. And thank goodness for you and for people like you who are willing to stand up. Fortunately, it seems like when enough time passes, the truth and freedom ends up being victorious, as we continue to see here, as we see with our lawsuit on AB 2571, which is the Junior Sports Magazine versus Bonta lawsuit. Shauna, I guess maybe we can round this out here. As we normally look forward to what potentially is to come with lawsuits, as we see them go through the court system, we see this victory at the Ninth Circuit. Ninth Circuit. That is a 3-judge panel. We see a lot of these cases come up on an appeal for preliminary injunction. That's not necessarily the case here because we had a judgment at the federal district court from Judge Benitez. So here they're talking about a permanent injunction. But what we also see a lot is a stay put on these things with the opportunity to appeal. I guess my final question to you is, do you see an appeal to a Ninth Circuit en banc panel in the recent future here? And how do you see the rest of this playing out?
Sure. I mean, it's always hard to tell, but if history is any indicator, I think that if I were a betting man, I would feel quite safe betting the house on the state seeking en banc review. Now, whether it gets en banc review is another question. Again, if history is any indicator, en banc review will be granted. The Ninth Circuit has yet to see a pro Second Amendment opinion out of a 3-judge panel that it did not take en banc and not want to overturn. So I think that's where the smart money is on this case being taken en banc, unfortunately, and potentially overturned. Although there are some things that distinguish this particular case in both respects. and the makeup of the Ninth Circuit is somewhat different. I think that the math still would support the taking of a case en banc, but whether it ultimately prevails en banc is a little bit more in our favor now. The odds are still against us, but in light of President Trump's last term, he appointed some judges who are pro Second Amendment, and there is a chance that we could get an en banc panel comprised of a majority of pro Second Amendment judges. And but this particular case, the dissent in the 3-judge panel is a little concerning in that it seems that Judge Beebe was not too upset with the state's system, that it's sort of he's kind of poo-pooing that it's not that big of a deal that people get rejected at such high rates and have these delays and have no guidance on how to fix their situation. And I think the fact that he doesn't struggle with that being a problem is not a good indication of how other judges who are not so pro Second Amendment might go about this. So, but yes, I foresee an en banc petition being requested by the state, and we will see whether it's taken. If that happens, the mandate does not issue from the 3-judge panel to the trial court, telling it that its rulings affirmed and putting the permanent injunction in place. So it could be weeks. I think it's like 21 days for them to request en banc review, and then the court will make its decision within another 21 days. So we do have some waiting and seeing here to do. Unfortunately, I know everybody's excited to get back to normal, especially after 8-9 years. But there is potentially, unfortunately, a little bit longer of a road here until we can claim total victory. But like you said, Kevin, this is progress. We're no longer just before a panel on a preliminary injunction that can be that has to go back down and litigated again. We're here on essentially a final ruling from what was essentially a trial, as Judge Benitez fashioned. It wasn't your typical type trial, but that's how he fashioned it. And so this is it, en banc review, and however that goes, the next step is SCOTUS. If the en banc review goes badly for us, goes in favor of the state, I assume we will go to SCOTUS. I don't know if the state would go to SCOTUS on this, to be frank. They might, and I don't know if SCOTUS would take it coming from the state. I don't know if they would take it coming from us either, right? But that's unfortunately the unknown road that lies ahead. But all we can do is take this victory and try to hang on to it as hard as we can, and that will be done by the CRPA and its supporters, all the plaintiffs like Ms. Rhode and all the companies that put their name on the line to participate in this case. The NRA, who financially supported this case on appeal, along with CRPA. So, thanks to all those folks, and I think that I know that we will continue and do everything possible to secure this victory permanently.
Yeah, absolutely. So needless to say, if there is a path forward in the courts with this lawsuit, it's got a lot of momentum in the right direction behind it, having seen 2 opinions, one an opinion and one a judgment from the federal district court in favor of gun owners, as well as now this one, which is the progress that we see in favor of gun owners from the Ninth Circuit. Well, to both of you, I just want to thank you both. That literally we're talking about years of work, years of advocacy on this case. It is great to see this opinion from the Ninth Circuit. I want to thank you both very much for that work, and thanks for coming on and sharing with us today.
Thanks for having us. It's a pleasure to be here.
Indeed. Thank you.
Absolutely. And guys, once again, if you like this kind of content, if you want to see more, we are talking to the people who are working in the courtroom. We're talking with the plaintiffs in these lawsuits. We're talking with the people working up in Sacramento on these legislative matters. And by subscribing to the channel, by becoming a member of CRPA, you are contributing directly to that cause. So please, once again, like, share, and subscribe to these videos. It really helps push it out as far and wide as possible. Thanks again, guys. We'll see you on the next one.